But so you were uh, the What is the difference?
Remember, Nick, really recent investment association.
We do.
Good morning. This is Senate Judiciary. It is about 8:30. Let's go ahead and get started. Holly, if you would call the roll for me.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott,
Excited to be here.
Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
Here.
Senator Stutz, Senator Weaver, Senator Barfoot.
Here.
10, and we have a quorum.
All right. Senator Orr, Senator Albritton, SB 24 with Senator Albritton. He's run a little bit behind. We'll come back to that. SB 103 with Senator Orr. He's run a little bit behind. We're going to come back to SB 143, Senator Gavan. SB 97 hadn't made it in yet, so we're going to go right to SB 154. All right, ladies and gentlemen, this is a bill that I sponsored the past 2 years. This is about driver's license suspension. Let me give you in a nutshell what that looks like. Current law, your license can be suspended if you miss any court appearance date. Your license can also be suspended. The court can suspend that if you miss a payment. This bill does not affect any pre-adjudication ability for the courts to suspend your license. It simply allows or mandates that in order for a license to be suspended for failure to miss a post-adjudication trial date, or excuse me, a post-adjudication review date, that you would have to miss 2 or more hearings, number one. Number two, it also stipulates that in order for your license to be suspended post-adjudication, that you would have to miss 6 or more payments. Now, there are those who say, well, this is an effort to make sure that the court costs or fines are not paid. Not the case. All court costs and fines ordered by the court will be paid, have to be paid, and this bill does nothing with that. There is another section of that bill that mandates that what an adjudication is. So let me give you an idea of why that language is in there. There are courts around this state who, if you are found guilty, plead guilty to a traffic violation, they may put you on a payment plan, and you may be paying it over the course of 2 to 3 years. And once you get through paying that court cost or fines on that ticket, then the court will send an adjudication letter, conviction letter to ALEA, which then assesses points 2 to 3 years after, in that scenario, 2 to 3 years after you have already been convicted. So that's another part of this, is that it mandates that upon conviction and after any appeal time has run, that the courts send that to ALEA so that whatever points need to be assessed should be assessed. There's still the ability for the courts, should you miss a court appearance date after an adjudication, to issue a warrant for your arrest and bring you in. Still there. Current law remains the law. There's still an ability for the courts, should you miss more than or a payment at any point in time, if you've paid religiously like you're supposed to for 2 years and then you miss a payment, guess what? The courts still have the ability under current law and this bill to bring you in for a contempt hearing, ask you why you haven't paid, and hold you in contempt if they find that your conduct is contemptuous. So this bill just addresses a couple of those things, that we give a little grace if you miss the first post-adjudication court date, and gives you a little grace from the standpoint of not suspending your license if you have missed less than 6 payments. So with that, I'll be glad to take any questions. Senator Smithman.
When you said the first adjudication, does just getting clarity, I have a couple of questions. Clarity on that is this, you're talking about the hearing for the court appearance? You know what I'm talking about, the first one. Or you're saying that during the course of this case that they can miss one court hearing? You see where I'm coming from now?
This is a post-adjudication hearing. If you miss any court dates prior to adjudication, a warrant can still be issued like current law, and your license could still be suspended.
Okay, Mr. Chairman, I wasn't asking for that purpose. Let me be clearer. What I'm saying is that if a person is going to court and they're told to be there today, and they missed today, okay, that's the first court appearance. Now, they go to court, been going to court for 4 times already, 4 times.
Are we talking pre-adjudication or post-adjudication?
Oh, yeah, this is before they're found innocent or guilty or whatever. This is why they got to come to court. Yeah. Pre-adjudication. Now, all of a sudden, my client has come 4 times, and it's at the 5th time they're supposed to be there, and they don't show up. So are we saying that any time prior to adjudication, they get one bite at the apple? That's what you see what I'm getting at now?
This has nothing to do with pre-adjudication. We don't change any of that pre-adjudication. It's all post-adjudication.
Well, let me say this. Let me say it a little different then. Forget all the legalese, because that's what we're doing now. Look, if I don't go to court, and I'm supposed to go to court,
right, and
I miss it on the first time,
okay,
then are you saying that that's what I call a free bite? So I get one bite at the apple, that is nothing that will happen to me if I miss coming here. Or my comparison and contrast is that I have come 4 straight times. I get a court date, come today. I get a court date next month, come. The next month, come. I get one in June, I don't come. So are we saying that at any time between when they're supposed to go to court, or whenever your cutoff point is, pre, post, or whatever, your cutoff point, do they get one free bite? And that's a free bite. They get one free bite to miss, and the only one you get is the first one, or is that somewhere during that whole string they get that free bite?
I understand your question. So it is only dealing with post-adjudication. So in that context, it is not just the first time that you miss. If you've been to court post-adjudication 5 times and you miss the 6th, they can't suspend your license. If you miss the first post-adjudication, any one missed court appearance post-adjudication, whether it be the first time or the 100th time, you get that bite of the apple. That's what we call giving a little bit of grace, or that's what I call giving a little bit of grace.
All right. The second question is about the payments. Based on what you said, my perception, I have to say it that way because it might not be what you said. My perception is that client I'm talking about can miss 6 payments. Is it 6 in a row, or 6 prior to the final orders?
6 prior to, it doesn't have to be 6 in a row. It has to be 6 missed payments during the course of a payment plan, using that as an example.
Okay, the last question on the payment plan is there any requirement for them to give some kind of notice or communication? And I'm saying that simply because, if you got a judge sitting up there and they open up that file and they see 5 months in a row they done missed, and we ain't heard from them, we don't know where they working, we don't know where they unemployed, they ain't asking for no mercy or no grace. by the court, they just don't show up? Is there something back on that person to let the court know that, hey, you know, I ain't got the money? You know, I mean, whether it's through their lawyer or whether it's them going down there and just telling the clerk or whatever.
That current law would apply then. If you don't show up for a post-adjudication review, one, at any point in time, you get a free bite at the apple. If you've missed 5 payments in a row, then your license can't be suspended. But under both of those scenarios, a warrant still could be issued for your arrest, and you can be brought in and for a contempt hearing from the court as to why you missed 1 payment, 5 payments, 10 payments. It's just at that 6 payment mark that you've missed. That's when your license could be suspended.
I got you. Okay. Thank you.
Thank you. Members, any other questions or comments?
Move favor report.
We had-
I have one comment.
Yes, ma'am.
You know, we go through these antics sometimes, and people don't understand what. I want to thank Senator Smitherman because he breaks it down in layman's terms. I'm not an attorney, and I think the discussion helps for the people who are watching, who may be like me. I always said, just break it down in layman's terms for me. Thank you.
Members, there's an amendment that Holly has reminded me of, and I apologize for that. And the clarification on that amendment is in your package. It is, I'll read it really quickly, replace line 49 on page 2 with the following: appear or otherwise fail to appear for any pre-adjudication court date or trial date. The original language said initial appearance, and we just made it clear that an initial appearance, as in an arraignment, and we just make that any pre-adjudication hearing included a trial date. So, motion to adopt the amendment, second by Senator Smitherman. Senator Weaver, did you have a question? Thank you. We're on the amendment. Got a first and a second. Let's have a roll call.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott,
Aye.
Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
Aye.
Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
Okay.
All right. Bill's given favorable report. We'll come back to the top of the docket now, or agenda. Senator Albritton, I believe you're first up on the list. Is your desire to proceed now, or you want me to knock this bill in the public hearing towards the end of the docket?
I'll do whatever the chair prefers. I'm ready and willing and questionable, capable to move forward with this.
Go right ahead then.
All right.
We do have a public hearing on it, so I'll advise the committee of that. I think y'all been put on notice of that.
Mr. Chairman,
Yes, sir.
I have a procedural question.
Okay.
Is it your plan that after this public hearing that we're going to vote on this bill?
It'll be the desire of the Senator Albritton.
That's fine.
We'll entertain his desire anyway.
Never mind. I just know that we got some committees at 9:30, education policy, some other
Right.
stuff as well. And looking at this agenda, I just
We probably won't get.
from my 10 years experience, we ain't finna get through in no hour.
No, I understand.
didn't get that now.
We put a pretty robust agenda on there. We figure we'll get to where we can get to. Senator Albritton.
Thank you. Ladies and gentlemen, what we have is Senate Bill 24 here. It is affectionately called the Indemnification Bill. I brought this bill last year, and it met with some resistance. So we set up a study commission by resolution, appointed members, and we also allowed other members during the course of hearings and such to come in and to join in anytime they chose. We had a very open policy with anyone that had a interest in this to come forward and discuss. We held at least 4 public meetings, all of which were an interesting endeavor and cerebral discussion in most instances to deal with these matters. And we came actually very, very close to resolving this and getting a consensus. But unfortunately, that has not happened. We have failed to reach a consensus on this. Now, all I'm trying to do with this bill is frankly codify what the Supreme Court of Alabama has already decided, and that is that you can't contract out your own wrongdoing to another. Now, that's a redneck opinion on this or a redneck statement on it, but frankly, what we have is we have general contractors that's in by contract with a subcontractor only with construction contracts that says you will indemnify me for any tort, basically. Now that's an overstatement, and I'm sure someone here will correct me along those lines, but it is a matter that we're trying. The larger GCs are trying to push the responsibility for payment onto the lower subcontractors. When a tort occurs, the small guy winds up normally in bankruptcy, cannot pay, cannot afford the cost of discovery and other matters that go on in judiciary matters. But when the settlement occurs, then they struggle and try to find out who else is going to kick in to have a settlement. What I'm trying to do with this is prevent the total indemnification from being shifted down. This is so that we can continue to do contract, but if you're going to do the contracts, do it earlier on, decide what the risks are, and move on. We thought we were close. We had insurance involved. We had lots of folks involved. There's always, as someone described this as triangular. It's not a circular, it's triangular. Every time we satisfy one side, the other two jump on them. And we've been going back and forth on that for a year. I brought this bill in order to try to continue the discussion. And unfortunately, my methodology has somewhat been poor because I think what I've done is caused everybody to dig in trenches harder. So now we're dug in from the North Sea down to Switzerland, and we're firing at each other, okay? So that's where we are. At this point, Mr. Chair, if we could just open up and have the public hearing at your discretion, how long you want to take, and hear the sides discuss and conflict. Let's see where the bombs go off, and then we'll see how we go, and I'll make a motion at that point.
Thank you. We do have a couple of folks signed up as proponents and several more as opponents of the bill. This is the first public hearing that I've conducted, and quite honestly, what I hate about the committee as it's structured, or the committees that are as they're structured, is we're limited in time to an hour. I think this bill and lots of other bills should receive lots of debate and discussion here. That being said, we're going to allow a couple folks to come up. We're going to try to make your point, if you could, and let the committee know what your thoughts are about it and why your thoughts are. Be as succinct as you can, and we'll try to give you about a minute or so apiece. I'm not going to hold you to that exact minute, but if I cut you off, don't throw stones at me.
Mr. Chair,
Yes, ma'am.
I have a question. If one knows that there are all these problems and you can't come to common ground, why would you introduce the bill and then have a public hearing on it, knowing that it's not really going to go anywhere, be resolved at a public hearing? And as you said, we have a robust agenda. I don't know. I'm trying to figure out what do you hope to accomplish here that you haven't accomplished at the table before submitting the bill?
Haven't you watched the old movie, Never Give Up, Never Surrender?
That's why you keep meeting with the people.
I believe we keep discussing. I think we have to keep the matter discussing. And the difficulties that I'd found, to be direct, Senator, is that people were not talking with one another. And they certainly were not talking with me as suggestions and such. As of this date, I'm unaware and have not been provided with any language for an amendment or for an adjustment or anything of that nature. So the only option I have as a part-time legislator is to bring it up and to try to move it forward. That's what I'm trying to do. And I am not convinced that there's not a path to solution here. 40 other states have already taken this step in the United States, 40 others. There have even been other places that in other matters, contractual matters, where they've done the same type thing. So it's not an unusual, it's not an anomaly, but it probably was my handling of the circumstances that my charming personality sometimes gets in the way of things.
Do you need to hire me as your mediator? It's just been
My
it's
budget
just
won't
been
allow
my
that.
experience. No, I'm sure, but it's just been my experience from being here. It's bills like this where you don't have people, you have all of these different interests and all over the place that you presented when you have a position, like as a chair of something, that bills like this have been presented and they were forced on the floor before us. It held up the Senate for days. So that's why I'm so into people coming to the table and resolving as many of those issues for sure before you introduce the bill when you know it's out there, but even before it's pushed to any level from committee to the floor or whatever, you should try to work them out. But at your pleasure, Mr. Chair. I just wanted to say that.
I appreciate your instruction, and I'll try to take it to heart, but
It's not my instruction, it's my suggestion.
thank you.
All right, with that being said, let's begin the public hearing. We'll first of all hear from one of the proponents, David Campbell. Mr. Campbell, if you could come up, make comments brief as possible, get your point across.
Mr. Chairman,
I will try as.
Mr. Senator, one second, Senator Smitherman.
at what point are we going to be able to chime in on this?
Let's get to the public hearing. If there's specific questions that any of these opponents or proponents need to answer, we'll get them back up.
But at the end, I would like to follow up with the sponsor on what he was saying regarding that, because I have some questions for clarity of understanding.
Very well.
Okay.
Mr. Campbell.
Thank you. Senators.
Mr. Campbell is a proponent.
Yes, proponent. Thank you. Thank you, Senator Figures. Senators, thank you for allowing me to speak to you today regarding SB 24. My name's David Campbell. I'm General Counsel of the Subcontractors Association of Alabama. I have over 20 years experience in construction litigation and construction contracts. This is extremely complex, even for lawyers, if you're not involved in this area. I'm going to break it down as simply as I can for you, Senator. Owner contracts with a general contractor. Following indemnification language is in the contract. GC agrees to defend, indemnify, and hold harmless owner, its representatives, affiliates, assigns, and for any claim arising out of or relating to in any way the GC's work regarding whether or not those acts are in whole or in part caused by the owner. Now, the GC uses that language with us, the subcontractors, which says you are going to cover us for everything in whole or in part, regardless, just because you've signed this contract. Subs don't do that. We don't have subs of subs, and we don't believe that's fair. We do not believe that you should be having to indemnify another for your own acts. So that's where it happens. So a claim arises with the owner. The owner tells the GC, the owner's sued. The owner says, GC, you're on the hook for everything. GC has 20 subcontractors. GC sends out 20 letters and says, it's yours. Even if the GC was wholly responsible, or even if the owner was wholly responsible, it's yours. So we have individuals who are going ahead and having to take on somebody else's responsibility, negligence, fault, or act. The only thing this bill is asking is we do not want to take on acts and responsibilities that are not covered under insurance. Sole negligence, we cannot cover somebody else for their sole negligence. Intentional misconduct, we cannot cover somebody. Even somebody can't get insurance for intentional misconduct. Wantonness, can't do it. Recklessness, almost never. All we're asking for in this bill is we do not want to be responsible for somebody else's actions for something that will bankrupt us. It'll put us out of business. They put that on us. We can't get insurance for it. And the GC says, I don't care whether you have insurance for it or not. It's yours. It's not mine. And it's all, the only nexus that they may have to it is they signed a contract with that broad indemnification language. So I want to be clear. There's nothing in this bill that says that subs, GCs aren't responsible for their own acts, even if there's no insurance. If they go out of business for their own acts, I do not want to go out of business, lose everything I have to fire my employees and everything for an act that you have that I can't get insurance for. If the owner wants insurance, there's plenty of insurance out there. The GCs and the subs are glad to pay for it. They're happy to pay for it. There's an owner-controlled insurance program, a contractor-controlled insurance program, builder's risk. There's a number of things, and we'll gladly pay for that. We just do not want to be put in a position to where we have to go ahead and defend. That's where you're going to go out of business, the defense, not necessarily the indemnification. go out of business for someone else's acts that are not insured.
Thank you, Mr. Campbell.
Yeah.
Next on the list, we'll have Mr. Proctor from McWayne Center. He is speaking from the opponent's standpoint.
Chairman,
Yes, sir.
so are we going?
We're going to get through the public hearing, and then you'll have a chance to ask questions, bring them back up if you want specifically for each individual. We'll give you that opportunity. Yes, sir.
What I was asking was that, take him for instance, he was up there. Now, so am I to record down what I want to ask him, and then we're gonna call him back, or do I do it while he up there? Because I have some questions for the
Yeah,
gentleman.
we'll bring him back. I'd like to get the
All right.
full standpoint from all the opponents and proponents, and then we may have a host of questions for each one of them. So, yes, sir. Go right ahead.
Mr. Chairman, members of the committee, thanks for the opportunity to come here today and express our concerns about this bill. Mr. Albritton. Again, my name is Jim Proctor. I'm Senior Vice President of Legal and External Affairs at McWayne. We're a manufacturer of various waterworks and other kinds of products. We have 4 manufacturing facilities here in Alabama that employ more than 2,000 workers directly, but also many, many more thousand indirectly through our supply chains. My role as general counsel gives me 2 perspectives on this. One is somebody who's got to manage the litigation that was referred to earlier, but also one that's responsible for negotiating the contracts with the general contractors that we were talking about. And let me give you the problem that we have with the bill is that it's currently drafted. It creates an unfair interference with the party's freedom of contract to avoid some unfair results. And let me give you an example of the situation I'm talking about. When we have a large project, we hire a GC. That general contractor is selected based on his expertise, his safety record, a number of other things. And the parties sit down and negotiate a contract that reflects the roles that they're going to play. And most situations, the owner has little or nothing to do with the manner in which the work is performed. But unfortunately, from time to time, people get hurt on the job. Typically, that's an employee of a subcontractor, but the subcontractor is not the only person that gets sued. We get sued as well. Why? Because we're the owner, we've got the deepest pockets in sight, and number 2, the contractor's got the benefit of the workers' comp bar. So they don't have any liability above and beyond the liability under workers' comp. As a result, we get pulled into the case, even though we might be a tenth of a percent responsible. But under Alabama's joint and several rules for responsibility, we're liable for the entire amount of the judgment, even if we're only a fraction of a percent responsible. And we incur tens of thousands, sometimes hundreds of thousands of dollars in legal fees and unfair settlements to deal with those situations, even though at the end of the day, we're really not at fault. Now, even though the legal system in Alabama, which is different than those other 40 states that have comparative negligence systems, where there is a mechanism to allocate fault, we are a joint and several system that doesn't have that mechanism, but there is a way to adjust that, and that's through the negotiation of contracts. The parties sit down beforehand. We sit down with very sophisticated general contractors, and we negotiate contracts that allocate responsibilities based on the unique circumstances of that particular project. And, the parties aren't always happy with every outcome, but generally it's fair and it works. The free market fixes the problem. Our concern with this bill is it puts the finger on the scale in favor of one group as opposed to others. And while I understand that as between the generals and the subs, sometimes they're unhappy with those outcomes, that's generally not the case with us and the general contractor. So when you pull the owners into the situations, you have an opportunity for unjust results. And the thing I would caution the committee on is this, is that we are a free market system. A fundamental principle in our free market system is freedom of contract. Let the parties, let the market work out solutions. If we're going to start making decisions about winners and losers based on who has political power in that particular moment, eventually that's going to produce some unjust results, and it sets a bad precedent for situations in the future. Thank you very much.
Thank you, Mr. Proctor. Mr. Greer with Nucor. He is an opponent. And to the extent possible, again, I just I hate to do this because I think this is where committee is important, but if you can, keep it as brief as you can, get to the point for me.
I'll make my comments brief.
Thank you.
Thank you all for allowing us to speak today.
So my name is Matt Greer. I'm controller with Nucor Steel. I'm at the Birmingham Rebar facility. So Nucor has about 2,500 teammates across about 11 different divisions within the state. I am speaking against SB 24. So like most large companies, we do have ongoing construction projects and are constantly evaluating new construction. In fact, we recently announced a new transmission tower production plant at our Decatur facility to employ about 200 additional teammates, and is one of two facilities totaling an investment of about $270 million for our company. So under the current language of SB 24, we would be considered an owner and be unable to be indemnified against liability, as some of the other people have brought out. We do hire the general contractors to construct our facilities, who will then go on to hire subcontractors. Yet we have very little control over who those subcontractors are and what they do, and the results that that do come out. Also, during the contract negotiation process, insurance is negotiated and oftentimes pushed back to the owners. So we are incurring all of the costs, yet none of the benefit. Current and future expansion projects could be affected by this bill and possibly move to less risky sites as a result. So that's all I have to say. Thank you for your time.
Thank you very much. Next, we have a proponent, Mr. Chip Braswell. Mr. Braswell.
Good morning, ladies and gentlemen. I'm a retired roofing contractor. Started my business back in 1984, and I learned about indemnification the hard way, unfortunately. Like you mentioned earlier, I'm not an attorney, I'm a roofing contractor, so basically all I'm going to give you is a war story. You know, we're on a large contract, a large project, and we're up there doing our roofing, and we've parked in the designated area that the general contractor has told us to park our vehicles. And during the day, the general contractor's backhoe operator totals our truck. And so, you know, we file an accident report. Our insurance company pays us for the truck. They turn around and sue the general contractor, and due to indemnification, we have no grounds to sue them. So we had nothing to do with it. We're on the roof, we're roofing. They destroyed the truck, and I was not really happy with it. It's a large general contractor, called their in-house counsel and expressed my feelings on that, how unfair that was. And he said, well, what's your deductible? I'll pay your deductible. Well, that's okay. So what? Yeah. So we're talking not a whole lot of money, but on the deductible side. But like we mentioned, the exposure can get to areas where we're not and don't have the coverage. And then when you get into the legal defense part of it, you know, subcontractors are small family-owned businesses, and they don't have those kind of resources. And you know, our cash flow, we're basically out of business. And, you know, when we try to negotiate a fair subcontract with these generals, you know, they'll say, we'll negotiate schedule, we'll discuss, negotiate scope, we'll negotiate payment terms, but our indemnification is non-negotiable. They're not going to negotiate that. And so they say it's a business decision. You want to do the job or you don't want to do the job? We'll get the next guy. So we walk. So what do? They bring the next guy in. Does it cost the general contractor any more money? No, it doesn't cost him any more money because he makes them do it for our price. And so, you know, what does it happen? What does the owner get out of it? He gets a lower tier subcontractor. So, you know, it affects the quality, but like David said, it's primarily the welfare of the contractors going forward. I'm retired. I should just walk away from it, but I've been in the subcontractor business all my life since age 17. And I feel that the indemnification in this state needs to be, you know, looked at and amended.
Thank you.
Again, thank you all for your time.
Thank you, Mr. Braswell. Next on the agenda is Ronnie Browning. He is an opponent. Mr. Browning, same thing. If you could just keep your comments to a minimum. If something hadn't already been covered, I'd appreciate it.
Thank you. I'm Ronnie Browning, Director of Supply Chain Management for American Cast Iron Pipe in Birmingham. We're one of the state's oldest, largest pipe manufacturers in the state. I could say ditto to what two of the guys have already said. Based on SB 24, we feel like that it will impinge on our freedom of contract. We feel like it'll increase our liability. We feel like it'll be a deterrent to us being able to properly identify ourselves. We think we'll incur substantial legal cost and considerable liability. The unintended consequences, as mentioned before, I think this will hamper future capital projects, which will eliminate jobs for the state of Alabama. We appreciate you hearing us. We appreciate you allowing us to oppose this, and thank you.
Thank you. Appreciate your comments. I apologize. It's hard. I'm having a hard time reading the writing. Is there, I believe it's Gaston, Iron and Steel Council. Mr. Gaston, if you would come up and give us some brief comments about your opposition to the bill.
Thank you, Mr. Chairman. I'm Maury Gaston. I am a 41-year employee of American Cast Iron Pipe, but I'm here today in my role as chairman of the Alabama Iron and Steel Council. Alabama's iron and steel industry is located throughout the state with manufacturing facilities in every congressional district. We directly employ 15,000 highly paid, skilled, and professional workers, resulting in 77,000 indirect jobs. We have $1.5 billion in direct payroll and $4.7 billion in indirect payroll. Our aggregate output is more than $10 billion annually, and we contribute $700 million to state and local tax coffers. Our high-tech, environmentally sound processes require constant capital investment and ongoing modernization. These services are provided by skilled and sophisticated general contractors and their subcontractors. I'm quite confident every iron and steel manufacturing facility in the state has at least one project underway at all times. Transfer of responsibility and liability from subcontractors and general contractors to the manufacturers who are funding these expansions and modernizations will add cost to manufacturing iron and steel in Alabama and be counterproductive to the goals and objectives we have all worked so hard for here and been so successful in attaining. The Alabama Iron and Steel Council and our enormous and impactful industry across the state, Mr. Chairman, recommends against SB 24.
Thank you, sir. Next, we'll hear from Mr. Price with ABC. He is a proponent of the bill. Mr. Price. Brief comments, if you could.
And Senator, feel free to cut me off. I'm a lawyer, and so
I understand.
I sometimes need to be cut off.
I understand.
My name is Oscar Price. I'm a partner at Wallace, Jordan, Ratliff, and Brandt. I appreciate y'all giving me the opportunity to speak here today. I'm speaking on behalf of the Associated Builders and Contractors of Alabama, which is a construction trade association in the state of Alabama. It has about 475 members. Those members include owners, general contractors, subcontractors, design professionals, consultants, and suppliers. And so we had a lot of internal discussion about this bill. Now, first, I want to express our ABC's gratitude to Senator Albritton for his efforts to get this far. And I'm going to disagree with you on one thing. The problems were not Senator Albritton's, and I appreciate him taking responsibility for something that wasn't his fault. But a lot of effort went in to trying to get to where we are, to try to reach a compromise. Now, why did ABC ask me to speak? I have over 40 years of construction experience, dealing mostly with construction contracts and construction litigation. 30 years of that was in private practice, representing owners, general contractors, subcontractors, design professionals, consultants, and suppliers. But I've also spent 5 years as in-house counsel at Rust Engineering, and I hope some of us in the room remember Rust Engineering. At the time, it was the largest contractor in Alabama and was one of the largest engineering construction companies in the country. I spent 5 years actually as president of one of the largest roofing contractors in Alabama. So I've seen indemnification from all sides. We are here to support this bill, and I want to focus on one thing. I want to make this bring it down to lay people's terms, because that's what I need to understand. This bill really does two things, two very simple things. First, it precludes a party from requiring someone else to indemnify them for their sole negligence. If somebody can be indemnified for their sole negligence, we think that should be against public policy. That takes away their incentive to be safe. And I'm hearing a lot of opposition to precluding indemnification for sole negligence. But the second thing it does is it limits, and I want to stress that word, it limits a party's ability to require another party to indemnify them for their own negligence. How does it limit it? Okay, it limits it says you got to limit it to a specified amount, and that amount, you got to require insurance for that amount, and the indemnification is limited to that amount. So if an owner or general contractor wants $10 million of indemnification, the only limitation is you got to say that. The general contractor's got to tell the subcontractor, we want $10 million of indemnification. You need to go out and buy $10 million of insurance, okay? And then we're going to limit that $10 million to that. That is a very reasonable limitation on the right to contract. We are not saying you can't indemnify. It took us months of discussion between the various parties, and we think that that's an appropriate compromise. Yes, it's a limitation on the freedom to contract, but we have lots of those, and we have other states that. The question is it reasonable and appropriate?
Thank you, sir. Appreciate your comments. Next, we have an opponent, Mr. Jeremy Walker. Mr. Walker.
Mr. Chair?
Yes.
May I interject one particular thought to follow up on that? The bill does not put a dollar limitation. It only requires a limitation and requires that to be specified and be insured. Is that
Thank you.
correct?
To put whatever number they want on that.
Mr. Walker.
Thank you, Mr. Chairman and members of the committee. I will try my best to be brief. We appreciate the opportunity. I'm Jeremy Walker. I represent the Alabama Association of Realtors, 19,000 members across the state who do residential, commercial, and many other things, and oftentimes homeowners and commercial projects. We speak against Senate Bill 24. We're really having a hard time determining why this makes the situation better in the state. We've heard a number of the challenges. To take kind of a macro view on this, real estate and construction in our state and across the country is going through a lot of challenges. There are a lot of economic headwinds out there. Your contractors are going through increased material cost, labor shortages, supply chain issues, on down the way. If we're going to cut into their ability to negotiate contracts on the front end, we're going to make it that much more difficult for them. This is going to hurt homeowners who are going through new construction. It's going to hurt someone bringing in a remodeler if the contractor cannot negotiate at arm's length with subcontractors. There are many other things that are negotiated every single day: arbitration agreements, hold harmless agreements, as well as indemnification clauses. If the law needs to be tightened up, we're certainly willing to be partners in that. One thing I've not heard any discussion of, a lot of fear of lawsuits, a lot of fear of people being brought in when they have not done wrong. And we hear that. I've represented those cases in the past. But maybe part of this discussion should be litigation accountability and holding trial lawyers responsible for suing subcontractors who are not ultimately liable for the acts themselves. So I just bring that up as a potential solution.
Thank you, Mr. Walker. Next, we've got Mr. Cagle. Mr. Cagle speaks as an opponent. Mr. Cagle, good to see you.
Yep, thank you. I represent the Alabama Mining Association, so our members would be owners of construction projects. We've got a member now who's got an ongoing $700 million construction project for a new mine. And, you guys have a tough job. The reality is everyone in this room knows you're picking between the lesser of the evils. But it seems like this bill's, creating as many problems as it's solving. So we just advise some, caution there. Nothing's going to be perfect, but if you can at least solve more problems than you're creating, I think that's a worthy goal. Thank you.
Thank you, Mr. Cagle. I want to take Chairman's prerogative real quick. Anybody here from Manufacturer, Alabama?
Sir.
If you could come up for me, if you don't mind.
Sure.
You familiar with this document?
Yes, sir.
Passed around?
Yes, sir.
You the author of that document?
It was authored by multiple people, and we put it together.
Authorized it. You didn't put pen to paper on it, and you didn't authorize it, and you didn't check off on it. I'm assuming. I mean, there were other people involved in it.
Oh yeah, yes, sir.
And my comments will not be specifically to you, but I'll be honest with you. We get lots of paper in our office.
Yes, sir.
And it's very rarely that, at least me, maybe it's a fault of mine, that we have an opportunity to read over everything. But about last night at about 10:30, I began to read Manufacturers Alabama's comments.
Yes, sir.
And I find some of it offensive. I'll just be honest with you. And this is not the merits of his bill or the lack of merits of his bill, okay? And I am not singling you out.
Okay.
I just want this message to be delivered to the folks who authorized it, okay? First of all, there's some inaccurate statements in there. Second of all, there's some comments in here, some words on the paper that, quite honestly, I find a little bit, incendiary and ironic, right? We talk about picking winners and losers, and to some extent, this bill does. There's probably not a piece of legislation that comes through this body that we don't pick winners and losers. So that's just not the case with this bill, okay? Second of all, when we talk about because it's impossible to prove a negative, i.e. 100% lack of negligence, are you a lawyer?
No, sir.
Okay.
Not.
Alabama's a contributory negligent state, and the burden's on the plaintiff, okay? If a defendant is 1%, if the plaintiff is 1% negligent, guess what? Correct statement in here about comparative negligence. Alabama's a contributory negligent state, and the plaintiff gets nothing. So you don't have to prove a negative. All the defendant has to do is to prove that the plaintiff was partially at fault. Secondly, when we talk about comparative negligence, often a plaintiff chooses to collect from the defendant with the deepest pockets, even if their role was very small in the case. You know what? There's a jury system out there. There's the courts of Supreme Court of Alabama. There's all kinds of safeguards in place. Comparative negligence, meaning that the defendants in a trial share liability for a judgment based on their share of the blame. You're correct, Alabama, or this document's correct. Alabama's not a comparative negligence state. It's a contributory negligence. But comparative negligence simply is what fault the plaintiff is versus what fault the defendant is. And so from that standpoint, I don't think that's a fair assessment. It's not legally correct. I could go on. I'm probably going to kick myself for calling you up, and it's not meant to you. But I got my blood pressure up last night, and I woke up this morning, and I still had it on my mind, and I had to get it off my chest. And so from that standpoint, if you would deliver that message, Manufacturing Alabama is a great part of this economy of the state of Alabama, and its members are. And so this is not a dig at them, but rather it is comments on the document that I got. So if they have any questions, I'll be glad to have a conversation with them about that.
Thank you for your feedback.
Thank you. Senator Smithman.
Oh, are you through with it?
I think I'm through.
Not you, but I mean with the speaker.
We're through. We can go to the question and answer portion. Senator Smithman.
Thank you. First, I want to say that Senator Albright, I appreciate you bringing the bill because this is definitely a subject matter that needs to be addressed. I was kind of trying to hold my course as the chairman was telling me, to kind of collect my thoughts and then at the end be able to do that. And then sometimes, just like when he stopped there, he said, well, let me stop for a minute. Sometimes you get thrown a little bit off track. And my reason for making that statement is simply when one of our speakers got up here and said it's the fault of the lawyers. The fault of the lawyers because the negligence of a contractor, so whatever it is, not doing their job, so it's the lawyer's fault. Trial at that, that's a bash. We hear about a bill and you're trying to bash a profession who is only defending somebody or representing somebody who was injured. And I heard a speaker, Mr. Chairman, one of the speakers, and I'm going to say this. You can talk about all the legal costs you want to, but I'm just going to pick a number. Every one of these 5.5 million people in this state can go down that courthouse and file suit against them. You're not going to prevent in this legal litigation against a negligent act that happened. The owner of the house can go do it. The cousin can go do it. Anybody that's an interested party you can't contract everybody out from filing suit. Maybe the judgment may or may not can be controlled by mediation or that, but the fact that you got to go into court, ain't nothing you could. This bill don't help. It's not going to help one bit to keep people from having to go in court in their business if somebody want to file something. So it's misleading to come up to say that. The second thing, the cost, it's going to increase costs. because you're going to shift it over to the people. When you know, you make profit, that's why you pay your bills out of profit. But you want to make profit and then said, no, we going to keep this profit margin. It's an expense over here. We finna shift this over here. Yeah, that's how it happens. It shifts over there. But the bottom line is this, is that I have serious concern when we are trying to box in the ultimate consumer. Because that's who's going to lose in the very end of this whole process. Whoever it is that's in that contract or trying to get that service done. Because you're going to block out the top people who get the money off the top. You got the subcontractors or the people under here that you're going to shift responsibility to, that is very obvious that they may or may not have the resources. That's why they're the subcontractors. And then we're going to leave the consumer out there high and dry chasing somebody that's not responsible. Or if they're responsible jointly, then they don't have resources whatsoever. And the contract going to be left, the individual person going to be left holding the bag. That's what it is. And we got 2 or 3 of these bills floating around in this body in certain arenas that all the folks make the big money. Look, we're going to keep the money. We ain't going to be responsible for nothing over here, and you just get your best hold and go out there and try to get some help if you can, if something happens to you. That's what this is saying right here. And that's wrong. That's wrong to do consumers that way. This ain't about making all who can make the money and all that. This is about consumers getting the services and goods and being able to take care of whatever their need is. That's what we are for. We got elected by, every one of us got elected by 150,000 people, individuals. And that's what we're here for, is to represent the individuals. And yeah, these are individuals in our district too. Every one of them folks you said, let me say this, every one of them folks who you heard talk about what they do up there in Birmingham is in Senate District 18. Okay, so that's why you hear me talking. Every one of them is in Senate District 18. Okay, and I understand what they're trying to say, because I don't know if you ever heard of Stockholm Valves. They know it. I was the supervisor of human resource. Resource, not manager, but the supervisor of human resource for that organization. So I know all that. I know these companies. I've dealt with them consistently. So I'm just saying, still, having been on that side, you don't do this. So I applaud you for bringing it, for putting this out there, because it needs to be brought out there. And no, we don't need to be covering, and I say this here, we don't need to be covering everybody, protecting them from their wrongs and leaving this consumer out there to dry. We don't need, and I'm the last thing, I hate bullying. I hate it. And that's bullying. When you got, what the man with the roofing, I don't know where you're him, getting up there, he was right. He gonna say, you take it or leave it. You don't take it, I'm gonna get somebody else. Instead of negotiating from arm's length and coming with something, you're gonna be a bully. You take it or go on. You take the responsibility or you ain't get no work. Your family can't eat. That's wrong. That's wrong. Yeah, it happens. He just said it happens. That's wrong. And now they want to do that and then come in here, the little stuff that leaked through, we want to make sure we're not responsible too. That ain't right. Thank you, Mr. Chairman.
Thank you. I know Senator Figures has a question. Before we get to her question, is it your desire to have a vote on this bill today?
Look, I know I've challenged the status quo on this, Mr. Chairman. I think that's been abundantly clear that I have done a lot of work, and so have a lot of others, trying to resolve this. And I think this is an appropriate answer. It may not be the best answer. I want to continue the discussion. And as much as I would like to win this fight, meaning get it out of the committee, I would like to do that, but I'm not going to pursue that today. I'd like to give these folks an opportunity to continue the discussion. I'd like to present an opportunity for these folks to try to come to terms. I know that we have been close, But with that, I'd move to carry this bill over.
Thank you. You got a motion. We carry the bill over. Senator
I
Figures,
still
did you still have a question on that?
Mr. Presswell, is it Mr. Presswell?
Raswell.
Raswell, I have a question for you. When you told us your story and you talked about the deductible that they would give you, but what about the time that you will be out of having that equipment in terms of other jobs or whatever? Do you count that as also part of your loss?
It is a part of our loss, but I did not. But it's a big deal because we don't have a bunch of trucks laying around.
Right.
We don't have a bench, back there with 4 or 5 trucks waiting. So we had to go buy another truck.
And that takes time.
And that takes time.
Yes. Okay.
So yes, no, it was just disappointing that you're not even involved.
Yeah.
And you've, like Senator said, they've got all this money over there, and it was kind of, what's your deductible? I'll pay you deductible. Get out of here.
Like going to prison for a crime you didn't commit.
So anyway.
Thank you. I just wanted to make sure that all of that was a part of it. Thank you.
Thank you, Senator Figures. With that being said, SB 24 is carried over, the public hearing portion of that bill being concluded. Move to the next bill in the interest of time, SB 103, Senator Orr. It's a big conversation, and there are lots of other bills on here, so we may not get to anything else other than the SB 103. Senator Orr.
Thank you, Mr. President, or Mr. Chairman. This is a pretty simple bill. It would require the Ethics Commission to provide any exonerating evidence that they may have that comes their way in an investigation. I want to read, if you don't mind, Mr. Chairman, real quickly, a letter from the District Attorneys Association written last year. And it talks about the Brady case, which you attorneys will know, that'd be the requirement to give exculpatory evidence in a situation of adversarial in a prosecution situation. Because of the above rule, and that being the Brady case, the Attorney General's opinions and case law mandate a clear duty for the Ethics Commission to provide Brady information to a respondent pursuant to the statute it lists out there, 3625-4F. The Office of OPS strongly recommends the Ethics Commission adopt an advisory opinion that authorizes such disclosures to avoid running afoul of a respondent or defendant's statutory, constitutional, and due process rights. Frankly, even if the law were not clear regarding the production of Brady information, my opinion would be to always provide all Brady information as soon as practically possible. Our oath as prosecutors is to seek justice, not merely convictions. Therefore, we are held to a higher standard than any other participant in the justice system. The state's ability to take liberty, property, and or a person's good name is an immense power and must be restrained through a fair and transparent due process, which includes sharing any and all exculpatory material. The law requires it, and the public demands no less. I couldn't say it any better, Mr. Chairman.
I'll second that. Couldn't say it any better.
Mr. Chairman.
Yes, sir, Mr. Bell. Senator Bell.
I'm going to keep my comments very short on this. I move for a favorable reading, but I could say so much more in support of this bill.
But I have a question.
Senator Figures.
You go, I'll yield.
Okay. I wanted to ask, during our ethics training this year, I had asked the question, why is it that we can't have the names of the persons who filed an ethics charge on us? So this would not include that, but would you take a friendly amendment to include that?
I would want to research that more, but I'm certainly willing to talk to you. I don't have a position on it, but I don't want to do harm.
Well, the same thing, like you said, a person's name. When you've been accused of something and you're innocent, well, it hits the news. But then you have no idea where it came from, why it came. And I think you should be able to face your accuser, if you will. So I really like for you to do that so that it can be an amendment on this bill. I think every legislator would like that.
Let me make a comment to that. I don't know the exact number, but typically the public thinks about elected officials are the ones that are subject to ethics laws. And while that is true, there are hundreds of thousands of citizens who are not elected officials who are subject to the ethics laws of the state of Alabama. So
Anybody. I mean, I just think that when your name has been put through the mud and you're innocent, you should know who did it or said it. So I really would like for you to seriously consider that, Senator.
Thank you, Senator Figures. We do have a first. Second, Senator Smitherman. Yes, sir. Go right ahead.
I got credit for doing what's It said in one sentence or two if you need. What are you trying to actually do?
I'm trying to require the Ethics Commission, if they have exonerating evidence that they found out in the course of their investigation, that they produce that to the defendant or the accused before there's any, but just like in a normal criminal case. And according to the Alabama Rules of Criminal Procedure, I think it's Rule 16 or something, that requires the state to produce the evidence to get, that they go through that same measure. And as Mr. Mattson wrote, justice and fair play dictate it. And I think it's important for us.
So what you're saying is that in the discovery phase,
yes,
in the discovery phase,
right.
just like we make you laugh, just like I had to do Monday. I came up with some. I got to try Friday. I came up with some stuff, and the other person is supposed to have actually it's their stuff, but I still had to provide it because I came up with something that's gonna maybe exonerate them. Even though they receive the same stuff directly at home. So what you're saying, the same rules of evidence.
Right. Right now, that doesn't, they're not required to do that.
Well, I think that's great.
Mr. Chair, I just got one comment. And because we are elected officials, we are convicted in the public press before it even gets there. So really, I want to applaud Senator Orr for bringing this, but I do agree with the amendment that Senator Figures mentioned.
Thank you.
Well, to answer Senator Smitherman, say if you have a school teacher that a parent gets mad at and files a complaint, the Ethics Commission does an investigation, finds exculpatory material, they don't have to turn it over. They hold that, well, then they refer it or something happens where you make somebody mad, it gets referred out. That teacher's on the front page of the local newspaper and she's convicted before the DA gets, either the AG or the DA gets the information, and they get the information and says, whoa, well, here's this information that says you didn't do it. This stops that. This puts a stop to that. And because as you said, we're on the front page of the paper, everybody is, school teachers and everybody.
And to your point, Senator Bell, when you say convicted, you mean convicted in the court of public opinion?
Court of public opinion.
Yeah. Thank you. Any other comments or discussions about Senator Orr's bill? Have a first and a second. Have a motion for a long roll. Ms. Ogden, if you would read the roll for me.
Senator Albritton, Senator Bell, Senator Coleman Madison, Senator Carnley, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
Aye.
Senator Stutz, Senator Weaver, Senator Barfoot.
Aye.
Okay. 12.
All right, Bill's given favorable report. We're at 9:30 something now. The next bills on the calendar will be carried over, the possibility of putting them on the agenda next week. Thank you. This concludes